Larry Fletcher.
Yes, ma'am.
And so, Mr. Fletcher is on probation and cause number 21-37809 for the offense of possession of a controlled substance, a second-degree felony. That probation is from October of 2021. It was a
Whoa, straight out of the gate. The judge is laying it out. Not just one old drug charge, but now a manslaughter and an aggravated assault with a deadly weapon. If you're wondering, wait, how can someone be on probation and still pick up to brand new felony charges? Welcome to the legal minefield of probation revocations. This is where your past and present collide in court.
5-year deferred probation. And then it looks like we have two new offenses that have been indicted in cause number 25, DCCR 0838, an aggravated assault with a deadly weapon, and 25 DCCR 0839, a manslaughter charge. Mr. Wilkerson has filed a motion asking that I set a bond in the motion to revoke case.
Yes, Mr. Fletcher.
Hold on, is there any motions in the other two, or we're just talking about the
I believe the state filed a motion seeking to actually increase the defendant's bond.
in which case?
In both cases. In the MQRP, we filed a reply to the defense counsel a motion to set a bond. And then in the other two cases, the state, the aggravated assault and the manslaughter case, the state has filed motions to increase it.
Let me get that all pulled up real quick and then we'll get started. Hold on. I'm printing. I need to see all that. I just printed the response and it's okay. We'll get it. Are the PCs, I guess, or would be the same in
For the
manslaughter and the ag assault? So I'm just
They
printing.
came out of the same transaction.
Okay.
Occurrence.
Give me just a second.
Yes,
Hold on. All right. So there's no bond currently set in the motion to revoke. The bonds in the two new cases have been set at $50,000 each. So I've got a motion to set a bond in the revocation, and I've got a motion from the state to increase the bond and or modify conditions in the two new offenses, correct?
Yes, ma'am.
Okay.
Okay, so here's the chess match. The defense wants a bond set so Fletcher can fight his cases from the outside, while the state wants to crank up the bond, basically making it harder for him to walk free before trial. And in Texas, bond isn't about punishment, it's about making sure you show up for court and keeping the public safe. But when you add a fatal crash to the mix, safety suddenly becomes the star of the show.
With regard to the, well, I guess Mr. Coleman, you mentioned that you would be willing to stipulate to some things before we get started with witness.
I suspect Mr. Wilkerson will call these witnesses to talk about the length of residency and the ties in the community, those kind of perfunctory things. If he will shorten this proceeding, I'm willing to stipulate to those if Mr. Wilkerson.
I mean, to some degree, that is some of it, but obviously there are more intricacies involved, including the nature of the family, the length of work, things of that nature that I think all need to be put into play here.
And I don't mind hearing the evidence. I don't want to hear the same thing. They're here, and I appreciate they're here, and I'll take notice of that. But what I don't need is to hear from all of the witnesses the same thing about work and living and all that. So if you want to call one or two that have that information,
Absolutely,
that would be great.
Yes.
I just don't want it to be the same thing, and I'll take notice that they're here and that they would all say typically the same thing if that's what it is.
He's on bond on two of those cases. I'm calling the bondsman right now.
yes, he is.
He's already on bond. They filed a motion to increase the bond.
That's correct. So he, obviously this very tragic accident occurred one evening. There is no allegation of any substance use on the part of Mr. Fletcher contributing to the accident that involved the death of one of the one of the victims and the severe injuries to the other. There is
Notice how the defense carefully frames this as a tragic accident. No drugs, no alcohol. That's not just sympathy play. It's strategy, because if they can knock out the recklessness angle, the state's manslaughter charge gets shaky and that aggravated assault charge even shakier. But here's the million-dollar question. Was Fletcher speeding so much that it tips the scale from accident to criminal negligence?
some, I guess the state's theory seems to be on the manslaughter, that he was reckless in his driving on that evening, thereby causing the death of another in the course of that reckless behavior while driving, which then makes it a stretch when the state then moves on to an aggravated assault charge for the second occupant of the vehicle, because of course if there were the intent and knowing element present there of course would have been a murder charge associated with the death of the first occupant of the vehicle. We are not debating obviously the tragedy of this incident, Your Honor. Mr. Fletcher on the night in question was actually responding to a work call. That is the reason that he was out on this particular evening. It was not after curfew, it was work related. He works for Ryder, the truck company, Judge. He's a mechanic. And as the court's aware, several years ago, Mr. Fletcher had an issue with substance abuse. Unfortunately, that's an issue that affects far too many people in the community, our loved ones, or sometimes ourselves, our family members, parents, sons, brothers, sisters, children. But Mr. Fletcher has been serving his probation faithfully. He has been supporting his defendants, Your Honor. He is engaged to be married. He has custody of his biological 2 children, and then also takes care of the 2 current children of his fiance, and is now welcoming a 3rd child. They are expecting that child. Mr. Fletcher has employment to return to, Your Honor, in terms of while these matters play out in the judicial system. Obviously, there are the state seems to highlight Mr. Fletcher's driving record as a reason to change or deny bond in conjunction with the possession charge, which he is entitled to bond on. With regard to the driving record, I would simply say if that driving record, that, by the way, I have not seen certainly a certified copy of any driving record of Mr. Fletcher, but I have no reason to doubt Mr. Coleman's representations regarding that. There are certainly rules that the court could fashion. Obviously, Mr. Fletcher has a large family here supporting him, who have also been very supportive of the Thomas family since this tragedy. The allegation has to do in terms of Mr. Fletcher's fault in that death and that aggravated assault, which seems like a mighty jump in mens rea there, Your Honor, seems to be that he was traveling at such an excessive rate of speed on the night that when the person who disregarded the traffic safety device and entered a lane, failing to yield right away, Mr. Fletcher then did not have sufficient time to react and stop the vehicle because of his rate of speed. Obviously, we haven't had an opportunity to have our own investigators take a look at any of that evidence to be able to argue it at this point in the case, Judge. I only mention it so that the court is aware of the background context under which these allegations arise, and the sole issue at present right now in the defendant's or in the defense's opinion is whether or not to provide Mr. Fletcher a bond on the charge for which he was serving a deferred adjudication sentence and for which he has not been convicted, thereby, of course, making him eligible for bond in such a case. Obviously, Judge, the law has changed in a number of ways, and if this were a case where Mr. Fletcher were some violent person, prone to violent outbursts, aggravated assaults, as the state alleges one of these was, although I just don't understand how you...
I'm not going to get into the legal. I mean, they filed what they filed. That'll be a question for later. So,
the issue here, Judge, is whether or not to grant him bail while the allegations that form the basis of revocation of this bond come to be addressed by the court. Your Honor, as I mentioned, and I would like to put his fiance on just briefly, his mother as well. And
let me stop everybody. Here's what I'm inclined to do. I am inclined on the two new cases, the ag assault and the manslaughter.
And there it is, the judge's hammer drops. Not on bond amount, but on freedom to drive. This is huge. Even without deciding who was at fault in the crash, the judge basically says, your driving history is the problem. Translation, public safety greater than job inconvenience. And with multiple crashes on his record, that condition is going to be hard for the defense to argue against.
To, in part, grant Mr. Coleman's motion and modify the bond conditions. I don't believe I'm going to increase them, because I think I can modify them in a way that will hopefully ensure the safety of the community. What I'm going to do in cause numbers 25 DCCR 0838 and 0839 is modify the bond conditions in those cases and order as a condition of bond that Mr. Fletcher is not allowed to drive, period, ever, any vehicle while these cases are pending. It does concern me, the prior allegations with regard to driving. We've got 2010 a crash, 2012 a crash, 2012 maximum speed limit issue, 2013 speeding over 10% over, 2016 speeding greater than 15 miles over, 2018 another crash, 2021 another crash, and here we are with a crash where I'm not going to get into fault, but there is a crash and we've got someone that has passed away and someone that is seriously injured. So that if I'm going to require that. I understand there may be work issues, and that is what it is at this point. That is what I'm going to order in those two cases.
And I could understand that, Judge, but I would point out that the same issues of fault that belie this case, we're also uncertain of what...
It doesn't matter to me. We're going to stop having crashes no matter whose fault it is. When there's a common factor, and there's the same thing that continues to happen, I can't help but at least have some concern that there is at least some type of fault on some of those. You know, you don't get into that many crashes without something happening, okay? So my job is twofold: keep everybody else safe in the community and to do what's right with regard to you and your rights as well. But I've got to keep everybody safe, and based on that history at this point while the case is pending, unless something changes later with further order of the court, you are ordered not to drive, okay? And so I think just by the nature of obviously that order, I'm probably inclined to grant the motion to set a bond in the probation case. And so I am at this time going to set the bond in cause number 21-37809. I'm going to grant the motion to set a bond. I'm going to set the bond in that case at that's a possession. I'm going to set the bond in that case at $30,000. The condition of the bond is the same. You're not to drive any vehicle. It doesn't look, I think Mr. Wilkerson is correct. I'm just looking at past administrative hearings that there hasn't been an issue with any type of positive drug screen or anything like that. And
Not administratively, just but he is accused of, in addition to the manslaughter and the aggravated assault, accused of violating his probation with the possession of a marijuana case and also the receipt of
so what I'm going to require is the condition of that bond on your MTRP case is that you wear a drug patch if you make that bond at all times. You'll have 24 hours from the time you're released to get a drug patch put on. You have to go change it every 2 weeks on time. And it needs to be on there. You can't sweat off or whatever. You need to make sure it's on and it's testable every 2 weeks. Obviously, if there is a positive drug screen for anything in your...
Now we're in the compliance contract phase. No driving and a 24/7 drug patch. And before you picture a nicotine patch, this one's way less forgiving. It's like having a personal snitch glued to your skin, constantly testing for any drug use. If Fletcher fails even once, he's back in custody faster than his lawyer can say, Your Honor.
System. It's a violation of all of your bonds, and you'll be right back into custody with Mr. Coleman probably telling me I told you so. So make sure you stay clean, make sure you do get it changed when you're supposed to, and all of that kind of stuff. So that bond condition is the same on all 3 of the cases. All the bond conditions are the same on all of the cases. No driving and drug patch on all 3 cases. Anything else?
Just procedurally, Judge, ordinarily we would defer with these types of charges, new charges, we would defer the MTRP, we'll wait on that and proceed on the new case, particularly with how serious these are. However, in this case, I just want the court to know we would be looking to go forward with the MTRP first.
Okay.
For a number of reasons. So we're looking to amend that MTRP. We'd ask that it be set prior to a disposition in the new manslaughter or aggravated.
And you would be intended on putting on evidence of those new offenses in that hearing? I would.
For punishment, the punishment part of it is.
I mean, to prove up the MTRP.
We have other things that do with the MTRP, particularly the possession of marijuana, also the UCW, but there very well may be some additional testimony about those circumstances surrounding aggravated assault.
There obviously appears to be some additional information, or maybe just because of the size of the cases, I haven't had an opportunity to review everything.
Yeah,
but
so
there are some allegations that I'm hearing have not been at the forefront.
So let's do this. Obviously, you need some time to get all that information. If there's going to be an amendment, if you'll please take care of that quickly, make sure anything that's alleged in that Mr. Wilkerson gets any discovery with regard to any new offenses or alleged offenses that you intend to put. That way you guys can both have all the information. Mr. Wilkerson can do what he needs to with that information, and we'll set it for an announcement, and then we'll kind of go from that announcement on where to go next with regard to either the new cases first or the motion first. All right, sound good? All right, thank you. Y'all are excused, and thank y'all all for being here.
So now, we've got an upcoming showdown. Which case gets tried first, the probation violation or the fresh felony charges? The state's pushing for the violation first, and here's why. If they win that, Fletcher could be serving time before the manslaughter trial even starts. This isn't just about guilt or innocence anymore. It's about legal strategy, and the clock is already ticking.
Here, I don't want anybody to think, I feel like we could cut it a little short and get that taken care of. All right, you go back with the bailiff.
Thank you, Your Honor.
Yes, sir.